Welcome to NCSA 2020 Virtual.
Hi everyone, thank you all for coming to listen to this presentation. My name is Sarah Hautzinger. I am a senior at St. Mary's College, and today I will be presenting to you in the business of justice, an ethnography of the bureaucratization of a small town courtroom. So 2 summers ago, I completed an internship in a small town lower level courtroom. And after working there, I became curious about what influenced the culture of that courtroom and what influenced the interactions between the people who worked there. It's interesting because as I started to look more into the research on courtrooms, I realized there was a problem. There is a distinct lack of existing literature on small town lower level courtrooms. There is quite a bit of literature on federal courtrooms. So those are usually the courtrooms you hear about on the news. They handle those big sensational cases like murders or scandals. However, small town lower level courtrooms handle less serious cases. So for example, criminal misdemeanors, traffic infractions, ordinance violations, your everyday run-of-the-mill cases. What's interesting, though, is that these lower level courtrooms handle approximately 90% of defendants in the American criminal justice system. So if they're seeing so many defendants, why don't we have more research on these courtrooms? And so that's what influenced my research questions as I began my study. As you can see, I wanted to know more about what influenced the interactions between these courtroom workgroup members and more about those values that shape the culture of a small town courtroom. And just for reference, when I refer to the courtroom workgroup, I'm referring to the people who make their living by coming into work every day in the courtroom. So that it could include the judge, the prosecutor, the court clerks, the bailiff, maybe a court stenographer if there is one. I also wanted to know more about power, and more specifically power as related to the court clerks. As I'll mention later on in my literature review, we know a lot about the power that court clerks at the federal level hold, but we don't know as much about small town court clerks. Overall, I argue that courtrooms are shifting from places purely designed around the concept of justice to places that value the ideals of business. This growing emphasis on business represents the bureaucratization of small town courtrooms, in which quarterly reports and efficient customer service take precedence over patience and community. There are 3 theories that best work to describe and examine courtrooms, the first of which is Goffman's theory of dramaturgy as developed in 1959. In this theory, Goffman states that individual actors shape their behavior based on how they think others perceive them. So essentially, our behavior becomes a performance put on for the benefit of our audience. The second theory, social network analysis, isn't really tied to one specific theorist. There have been multiple theorists that have developed this theory over the years, but overall, it examines the underlying links between members of an organization and what affects those links and those relationships between those members. Social network analysis finds that power is especially important. It states that there are 2 kinds of power, formal and informal power. So an example of formal power would be the judge holding an advanced degree, a Juris Doctorate. However, an example of informal power would be the clerk knowing how to run the online case management system that holds all of the information about defendants. The judge might not know the ins and outs of that system quite like the clerk does, and so therefore the clerk does hold power, albeit informally. This is closely tied to Weber's concept of power, in which he explains that there are different types of authority. The one that is most applicable to the courtroom is what's known as legal rational authority, and in his theory on this, Weber says that all parties must agree on what constitutes power. But what happens when people don't agree on what constitutes power? Most of the literature on courtroom work groups focused around these 3 themes, the first of which is interactions among courtroom workgroup members. Much of the research found that courtrooms that have high levels of familiarity and similarity, so those where the workgroup members knew each other very well and where they were similar in terms of age, gender, race, even political party affiliation, those courtrooms are more likely to get along more and to have better lines of communication. Additionally, it was found that court clerks at the federal level, so for example, Supreme Court law clerks, hold a tremendous amount of influence. It was even found that Supreme Court law clerks influence how the justices that they work for how those justices vote in cases that come to the Supreme Court. The other two themes in my literature review focused more specifically on gender. Of course, we know that gender is a very important status when it comes to the workplace, and because of this, American society tends to think of certain occupations as being associated with one gender more than the other. For example, when you ask people in American society to picture a judge, they usually think of a man. However, when you ask them to think of a clerical support staff person, they tend to think of a woman. This is closely linked to my third theme, power in the gendered workplace. Previous research has found that men are allowed to behave more assertively in the workplace. They're allowed to assert dominance and tell others what to do without fear of backlash from other people. However, when women do that, as one study put it, they're seen as being, quote, bitchy and bossy, end quote, by their colleagues and coworkers. And so therefore, they're not allowed to demonstrate their power, and they're expected to behave more democratically than their male coworkers. For the methodology of my study, I chose to employ an ethnography, which is when you look at an overall group or community and how they demonstrate their community culture in what they say and how they behave. This data is usually collected through qualitative interviews, which focus on words and not numbers. So they're usually semi-structured or unstructured, they're detailed, and they're conversational. So they allow for very rich, complex, in-depth analyses of the data. My interviews that I did for my study were conducted in the summer of 2019, and the study was approved by the St. Mary's College Institutional Review Board. My sample consisted of 6 employees from a small town Midwestern city courtroom, and all of the participants were white with their ages ranging between 29 and 52 years old. As you can see from this chart, I was interested in the gender and the highest level of education achieved by each participant. So the judge and one of the prosecutors were both male, and the highest level of education they received was a Juris Doctorate as required of all lawyers. The other prosecutor and all 3 of the court clerks were female, and the highest level of education achieved by any court clerk was an associate's degree. So overall, the court clerks were more likely to be female and less likely to be as highly educated as the lawyers were. My interviews ranged between 30 to 45 minutes long, depending on the participant, and they were broken down into 2 sections, the first of which covered basic demographics. So I wanted to look at the age, sex, highest level of education received, relevant employment history for each participant. And then the second question looked at certain themes, and these themes were usually covered in the form of open-ended questions. These themes listed here were deemed to be important based on previous literature by Eisenstein and Jacob and Hanserbeck and Cusack. So for example, looking at perceived similarity and familiarity or norms and socialization. Based on the data I collected in these interviews, there were 3 findings that most of the data was centered around, the first of which was ties formed on the basis of family and small town interactions. I have this quote from Judge here, and he's talking about the court clerk he feels he knows the best. And he says it's because they have similar backgrounds, their kids are involved in the same thing, and they go to the same church. Judge's quote demonstrates how people in this courtroom work group get to know each other, and how family and small town interactions are so important. Family is a way for people who work there to demonstrate their familiarity with each other. So one prosecutor mentioned he would bring his kids in to see the courtroom and to meet his coworkers. The court clerks would mention that they would invite each other to their kids' graduation parties or to sporting events. Additionally, small town interactions are important because this courtroom is located in a small town. These people are likely to see each other outside of the workplace, whether it be at the grocery store or at the church or at the mall. So therefore, when they see each other outside of the workplace, informal interactions are likely to occur, and these informal interactions could influence who has power. This is evidenced by the fact that everyone has different perceptions of what constitutes legitimate power, which is my second finding. So in my interviews, I asked each participant who makes certain decisions in the courtroom. So for example, who decides case outcome, who orders supplies for the courtroom like printer paper and ink, and then who plans a birthday when one of the coworkers has a birthday. There are 2 things I'd like to point out here. The first of which is this first column here. who decides case outcome. So judge and each of the court clerks said that judge is the one who decides case outcome. However, the two prosecutors both said that they were the ones who decide case outcome. And this is interesting because deciding case outcome is arguably the most important decision that can be made in a courtroom. So clearly, judge and the prosecutors have very different perceptions of who holds this legitimate power. I also want to point out judge's response for this middle column here, who orders supplies. Judge said that the clerks in general order supplies, but every single other participant said that clerk 2, who is the court administrator, is the person who orders these supplies. By not naming one specific clerk as the person who orders these supplies and makes this decision, judge is minimizing the power of the clerks and he's minimizing the legitimacy. This is further emphasized in these quotes I have from judge and prosecutor too. When asked about the role and the function of the court clerks, judge said they're basically responsible for intakes. They take information about cases and they put it into the online computer management system. Prosecutor 2's rhetoric, on the other hand, is slightly different. He says they are, quote, so important, and they do so many things behind the scenes, and you can really take the court clerks for granted. And so therefore, these two very different tones show that different actors in the courtroom can minimize other people's power, and they can minimize how legitimate it seems. My last finding, and my most important finding, was that the actors see the courtroom as being this place of duality. It's a place of justice and a place of business. It's first a place of justice as viewed by the lawyers who see themselves as stewards of justice. In this quote, Prosecutor 2 is saying that he's essentially the helping hand for defendants in the courtroom. He wants to get them out of the criminal justice system and back into their communities, and so that they can become rehabilitated. This view of the courtroom is a very traditional view. It's usually how we see the courtroom as being this place of justice where we can help defendants and improve our communities. This quote on the right over here, Judge's quote, explains that some of his most important duties include reporting finances and statistics as mandated by the state. So every quarter, he has to report the total number of new cases, what their dispositions are, how many go to trial, etc. These words, quarterly, stats, finances, all have a very business-like connotation, as do what the court clerks say about their jobs. All of the court clerks use the exact words customer service to describe what they do. And so again, customer service is associated with businesses. So judge and the court clerks are emphasizing that they see the courtroom not necessarily as a place of justice, but also as a place of business. Because we're seeing this shift from an emphasis on justice to an emphasis on business, I argue that we're seeing the bureaucratization of small town courtrooms as we move into courtrooms as businesses. We can see this especially in the implementation of bureaucratic standards. In his concepts on bureaucracy, Weber explains that for an organization to be considered a bureaucracy, it has to meet certain standards. The courtroom in this study does meet multiple bureaucratic standards, but the most important one here is the need for specialized hierarchies. Before this summer, the power hierarchy in the courtroom was very simple. It was judge and then the prosecutors and the court clerks. However, a few months before I conducted my interviews, judge named court clerk 2 to be court administrator, which meant she had a couple extra responsibilities, namely helping judge report those finances and stats to the state. In doing so, and in implementing this new role, judge changed the hierarchy of the courtroom, and he makes it more specialized, as you can see by the flow chart on the right. Because of this hierarchy is more specialized, which is indicative of a bureaucratized organization. We can also see this bureaucratization and this rationalization process in the American educational system. As professors and students can attest, there have to be learning goals in classrooms now, and students have to be able to meet these learning goals, otherwise they're seen as being dissatisfied customers, essentially. Therefore, there's this emphasis on meeting standards, and we can see this meeting standards idea reflected in the courtroom. Courts now have to report their case outcomes to the state in terms of finances and stats, but What happens when the state reviews those outcomes and they say, oh, this courtroom isn't going through enough cases, or this courtroom is going through too many cases? There could be an increased emphasis on efficiency, which we're already seeing in what Myers calls this culture of adjournment. Myers explains that there are already some bail courts who are so focused on efficiency and getting through as many cases as possible that their routine becomes that of adjournment. If a difficult case comes up and they don't really want to go through it or spend the time going through it, they adjourn it for another day, which means that defendants' cases can drag out for months and even years at a time, which is of course painful for defendants who want to get their cases heard or dismissed as quickly as possible. This shift towards efficiency is dangerous for a couple of reasons. We're moving away from courtrooms as being traditional places of justice and rehabilitation, places where we can really focus on lowering recidivism rates by focusing on defendants and getting them the true help they need by giving them due process. Instead, we're moving toward courtrooms as places of hyper-efficient decision-making. And in doing so, we have to ask ourselves, is this justice? Is this really what we want our American courtrooms to be like? Do we want them to be places of justice, or do we want them to be places of business? I invite you to imagine if you were a defendant walking into a courtroom to have your case heard, which would you prefer? Would you prefer a courtroom of traditional justice, of fairness, of compassion, and even empathy for defendants? Or would you prefer a hyper-efficient, business-like courtroom where you might not be seen as a defendant, you might just be seen as another number? Thank you so much for your time.